students. Good evening, my dear students. I'm very pleased to be with you in teaching the subject of practical applications, which is the Anglo American Law. With you, Muhammad Wahba, Civil Law Department, Teaching Assistant in Civil Law Department, Faculty of Law in Shams University. Before starting to know what is the Anglo-American law, we shall firstly know the idea or a brief idea of what is meant by comparative law. The idea of comparative law is based on the study of the laws which enforce in different nations, which is seeking to providing the way for the advancement and supremacy and the reform of the national laws. Comparative law is a branch of legal studies which mean the comparative legal studies of laws. This study does not limit it to one branch of law, but is different according to which branch of law the researcher specializes. Comparative legal studies can exist in any of the different branches of law. For example, we have a branch of civil law or public law or administrative law. In each country, we have several branches of law, public law and private law. Each branch involves certain laws. For example, the civil law are the branch of private law in Egypt and France. Despite, in this case, the branch is one branch in the two countries, but according to the comparative study of legal laws or legal rules, in this case, we're comparing between the details which contains in each branch of them. And the comparative law in this case, meaning that when we compare between the civil law in France and in Egypt, we find that each branch in those two countries involves central legal rules, whether these rules are related to the contract, to the legal capacity. However, another example, also when comparing between the branch of administrative law between France and Egypt, we find that each branch in France or in Egypt have its own structure and the procedures and jurisdiction. These examples to know the idea of the comparative legal study between several branches in several countries which adopted in several legal systems. يعني ايه الكلام ده؟ يعني احنا عشان نعرف عشان نعرف ايه هي او ايه هو القانون الانجلو امريكان بصفة عامة، لازم الاول نبقى عندنا فكرة ولو بسيطة عن فكرة القانون المقارن، او يعني ايه القانون المقارن. القانون المقارن ده او فكرة القانون المقارن هي عبارة عن دراسة لأنظمة مختلفة لعديد من الدول، بناء عليها بنعرف مدى وقوف الدول على تطورها في العديد من الأنظمة القانونية التابعة لها. وبنجد هنا أن الفائدة من دراسة القانون المقارن بصفة عامة، على سبيل المثال لو جه المشرع، إذا حب المشرع أن يعدل بعض القوانين في مسائل مختلفة في فرع معين من فروع القوانين الخاصة دولة معينة مثلا، هنا المشرع يجب أن هو ينظر إلى قوانين الدول الأخرى أو بيسموها القوانين المقارنة من أجل الوقوف على بعض النقاط، لعل وعسى أنه من الممكن أن يجد ثغرة كانت في القانون الذي يريد به التعديل أو يراد به التعديل، ومن ثم يجد الحل مثلا في القانون الآخر المقارن، والعكس صحيح. يعني إيه والعكس صحيح؟ يعني ممكن إن المشرع لما يجي يبص في قانون الدولة عنده أو فرع معين من فروع القانون اللي بيطبقها، وينظر إلى فرع من فروع ذات القانون في دولة أخرى، من الممكن أن يجد أن القانون الوطني أو قانون المشرع الوطني أفضل وأحسن بكثير من القانون الأجنبي الذي يقوم بدراسته. والدراسة المقارنة لا تقتصر على دراسة أو مقارنة فرع واحد من فروع القانون، ولكنها بتشمل أفرع عديدة أو دراسة لأفرع عديدة من الأنظمة القانونية المختلفة التي تتبناها العديد من الدول. على سبيل المثال مثلا لو نيجي عملنا دراسة مقارنة بين القانون المدني في مصر أو القانون المدني في فرنسا، باعتبار أن القانون المدني ده أحد فروع القانون الخاص. مثال آخر برضو لو جينا نقارن القانون الإداري أو القانون العام، نقول القانون الإداري بما إنه أحد أفرع القانون العام، لما جينا نقارنه مثلا القانون الإداري في مصر والقانون الإداري في فرنسا، سنجد طبعا أن بالرغم أن القانون أو المسمى واحد في كلا من الدولتين، ولكن هناك فروق أو في تفاصيل بتختلف في النظام المصري أو في القانون المصري عنها في النظام الفرنسي. يعني لو جينا نبص للقانون المدني هنجد أن طبعا هناك قواعد متشابهة ما بين القانون المدني في مصر والقانون المدني الفرنسي، ولكن هناك بعض التفاصيل هي دي محور الاختلاف ما بين القانونين. يعني مثلا لو جينا نبص مثلا للعقد مثلا أو فكرة أهلية التعاقد أو أهلية الأطراف في التعاقد، من الممكن أن أجد بعض القواعد المتعلقة بأهلية التعاقد أو العقد في القانون المصري تختلف عنها بعض الشيء في القانون الفرنسي. ومن خلال تلك الدراسة المقارنة لفروع القانون المختلفة على مستوى دول مختلفة، من الممكن أن يجد المشرع حلا لثغرة كانت في القانون الداخلي أو في التشريع الداخلي، ولولا هذه المقارنة ما كان ليجد هذا الحل. وبنجد هنا الفايدة أو الأهمية من الدراسة القانونية المقارنة. Thus, the comparative legal study have a huge importance. Why? Because when the legislature wants to modify a certain legal rules in order to be consistent with the social and economic circumstances, when he compare between the branch of law and the other branch of the other country, he may find a solutions for a certain case or a cases in the national law and find their solutions by the comparison of the other laws of the foreign laws. يبقى the main importance of the comparative legal studies, it is in order to eliminating the shortcomings and the gaps of the legal rules which is required by economic and social and political circumstances. Thus, the study of the comparative law requires the study of the foreign laws besides the study of national laws, that we shall know that there are many foreign laws as each state have its own law which is consistent with its social, political and economic circumstances. Moreover, there are many legal systems in one state, especially if the state adopting the system of federal state. This means that there are some states adopting many legal systems in the one state. For example, United States of America adopting the system of federal state. Besides that, it have a several states, every state have a certain law governing to it. يعني ايه الكلام ده؟ يعني الدراسة القانونية المقارنة دي معناها دراسة القوانين التي تتبعها الدول الأجنبية أو دراسة القوانين الأجنبية للدول المختلفة بالمقارنة بيها مع القوانين الوطنية للدولة. بل إن إحنا في أحيان بنجد إن ممكن دولة واحدة بتتبنى أكتر من نظام قانوني بداخلها. يعني إيه؟ زي الولايات المتحدة الأمريكية أو زي أمريكا بتتبنى في عندها نظام اسمه نظام الدولة الاتحادية. يعني إيه؟ يعني في قانون موحد بيسري على كافة الولايات التي تتبعها الدولة، وبجانب ده كمان هناك قانون لكل ولاية على حدة، قانون لكل ولاية على حدة، لكل ولاية قانونها اللي بيحكمها. سواء بالنسبة للانتخابات أو التعيين في الوظائف العامة. كل ولاية ليها قانون متعلق بها، بالإضافة إلى القانون الموحد اللي بيسري على الدولة كلها أو بيسموه القانون الاتحادي، لا سيما إذا كانت في دولة اتحادية أو فيدرالية زي الولايات المتحدة الأمريكية. So, in order to know what is meant by the Anglo-American law, we shall differentiate between two main legal families or two main legal systems applied in the world. First one, the Roman legal family or the civil law systems. The second category, we have the Anglo-Saxon legal family or the common law system. Thus, we have two main legal families in the world. First one, the Roman legal family or the Roman legal school, which is adopted in more of countries around the world. It also means civil law system countries. And the second category, the Anglo-Saxon legal school or the common law system. As regard to the first category, which is the Roman legal family or the Roman legal school or the civil law system, which is the most prevalent legal system in the modern world and the oldest in human history. According to the Roman legal family, the legal rules which adopted by this school or this family found its basis on which is meant by codification. This system is based on the codification, which means a group of written principles which made by the legislature to be applied in the future as the rules of law, which means that each branch of law that adopted by the Roman legal system have a certain code, collect certain legal rules related to a related branch of law. For example, civil law, commercial law, criminal law. Each branch of these branches have its own rules collected on one code, means codification. Also, the judicial system in the Roman legal school is classified into two classes or two categories. First one, ordinary courts. Second one, administrative courts, which is mainly here dual judicial system. We have two types of courts. Each one of them deals with certain cases. For example, in the ordinary courts, these ordinary courts deals with civil and commercial and criminal cases. On the other side, administrative courts deals with all administrative disputes between the state and the persons. On the other side, which is Anglo-Saxon legal family, according to this law school, the legal rules is not written legal rules, but this system is based on the system of precedents, or stare decisions. This means that when the judge discusses a certain case in front of him, he does not decide according to a certain legal rules written in certain codification, but he decides the case according to previous cases issued by a superior courts, and according to these judgments of the previous courts, superior courts, he decide the case which he discuss. Moreover, the judicial system in Anglo-Saxon legal family, it is based on a unified judicial system. According to this system, we have one court system, ordinary court system, which is dealing with all disputes, whether civil, criminal, administrative, also whether their parties, ordinary parties or authorities which belonging to the state. and each one of those two legal systems are adopted by several countries. If we look to the comparison between civil law system and the common law system, first, as regard to the applied legal rules, we have civil law system or the Roman legal system, and on the other hand, we have common law system or the Anglo-Saxon legal family. As regard to the civil law system or the Roman legal family, it is the most common and the prevalent legal system in the modern world. It is based on the system of codification. We mean that by the codification, it means that a group of rules, written principles or written rules made by the legislature to be applied in the future to all the cases. On the other side, common law system or Anglo-Saxon legal family, it is also called Anglo American law or judge-made law or common law. This system is based on the law created by the judge, which means the principle of judicial precedence. Judicial precedence means that when the judge discusses a certain case in front of him in certain dispute, his decision depending on the decision of previous case issued by a superior or a higher court. Thus, the difference between two legal systems as regard to the legal rules in civil law system, the rules made by codification, and in the common law system, the rules is made by the judge. Also, in the civil law system, we have some countries adopting the civil law system. The most famous example which adopted by the civil law system, we have France and Egypt and Germany and Italy and Japan. On the other side, in common law system, we have several or more countries which adopting this system, mainly England, USA, Switzerland, India, and some other countries. The second comparison between those two legal families is the comparison as regard to the court system. As regard to the civil law system, we have the court system which depends on the dual judicial system. The dual judicial system based on the existence of two independent separate judicial bodies, which mainly ordinary courts and administrative courts. Both of them have their own structure and procedures and jurisdiction. As regard to the ordinary courts, these courts dealing with the civil and commercial and criminal cases, while the administrative courts dealing with the disputes which one of its parties is the state. Thus, the dispute before ordinary court is between ordinary persons, while the, the persons or the parties in administrative disputes are ordinary persons and the state or the public authorities. On the other category in common law system, the court system is based on the unified judicial system. Unified judicial system mean that there are one regular courts contrary to dual judicial system, which does not know specialized administrative courts. This means that we have one ordinary regular courts which have the power to settle and resolve all kinds of disputes, whatever their nature, which is civil or administrative, or whether it's parties, whether they are individuals or public servants. The dual judicial system is applied by certain countries, and the common law system or the unified judicial system also is applied by several countries, as we talked about. Thus, we shall refer to the conclusion of the book that the book contains and provides us with general information on certain selected topics of law in both USA and British legal systems. Also, we have some topics in order to be teaching them relating to the English system and the American system. Each topic or each chapter is covered by some exercises taking the form of true or false in the end of each chapter. Also, we have in the end of each chapter a glossary which contains a group of legal terms which help us to understand the texts when we are reading it in each chapter. So we have in